I am going to talk about the most solemn times of the marriage where you are exiting. Things don't work out and you have to exit. What happens? What do you take out? So we'll be looking at my very good friend and sister, Mamiya, has already talked about the evolution of the law on property, spousal property rights. So I'll just talk about how it applies. In Ghana, as we have it now, the legal framework that governs the property rights of spouses is found in two main legislations. That is the Constitution, that is Article 22, and we also have Sections 20 of the Matrimonial Causes Act. I don't know if anybody here has ever come into contact with the Matrimonial Causes Act. That's any divorcee, there are lawyers, the lawyers have come across it, so I'll just leave that. Now, Article 22 of the Constitution, with specific reference to at Clause 3A, talks about the fact that in the context of marriage, any property acquired jointly by the spouses shall be distributed equitably on dissolution of the marriage. Now, I took my time to emphasize certain points. In the context of marriage, that's one, equitably distributed and jointly acquired. So let me start addressing you on when Article 22 of the Constitution would apply. Now, more often than not, the mothers here, the fathers here, you have daughters or sons who are in relationships. And in the course of the relationship, you notice that the boy or the girl, they want to put resources together and do some investments. All this, sometimes they even acquire lands, they build houses, they buy properties outside the marriage, in the hopes that when they marry, they'll utilize those assets. Let me just tell you that so long as these investments or acquisitions happened outside the context of marriage, you cannot come under Article 22 of the Constitution, because the properties should have been jointly acquired within the context of marriage. Now, the next thing we have to also look at is, when we say jointly acquired, what do we really mean? And I want to take you back a bit to our social and cultural setup. You will notice that for a very long time in Ghana, men were economically privileged. Said that there's a saying among the Akans that's "Obato tua, echibema." So even if the woman acquires a lot of assets, sometimes they register it in the name of the man, or they'll ascribe it to the man as his property. So more often than not, you would notice that in the context of divorce, as Mamiya already said, the position was that the woman gets nothing, you walk away, unless you are able to show that you contributed financially towards the acquisition of those assets or properties. But fast forward to 2012, and thanks to the Supreme Court, we had a drastic shift in that position of the law, where the Supreme Court now decided to look at the contributions. And I see a counselor here who used to be on TV. I don't know if she's still there. And they talk a lot. They advise couples, people who want to marry. And in the course of the advice, I believe you tell women certain traditional rules and men what their rules or expectations are as husbands. So in going into the context of marriage, there is an expectation of the role of the man and the role of the wife. But with the previous position of the law, there was no recognition accorded to those roles performed by the wife because it was not financial. But 2012 onwards, the Supreme Court started recognizing those things that the woman does in the house, like cooking, washing, taking care of children, sweeping, and even just staying at home while the man can go without hiring a security person, knowing that there's someone taking care of the home. The Supreme Court quantified this into contribution of the woman. And based on that recognition given to the works of the woman, now we develop the doctrine of presumption of equality, that so long as the woman has contributed by way of doing these things towards the acquisition of these properties, then all those properties will be presumed to be equally owned and therefore presumed to be equally shared. Now, that has been the position of the law since 2012. But there has been some modifications because also under our laws, we have the right to own private property. So the courts will have to reconcile the right to own private property as against the right to own property within the context of marriage. And in some instances, the courts have taken the view that marriage will not necessarily take away my right to own private property. But we are still left with a difficulty. How do we know that this particular property that Madam has acquired is for her exclusive use to my exclusion? So that in the context of divorce, I cannot make a claim or lay claim to it. So the courts have laid down certain criteria for determining some of these things. But I'm a man, and men can be very crafty, and excuse me, when it comes to some of these settlements. So more often than not, you notice that properties acquired are all in the name of the man. And as a lawyer, sometimes you have women come to you and they'll say, lawyer, and it permits me to just speak chi at this point. Lawyer, so these are the genuine issues that confront people in the course of divorce. But more often than not, you notice that a lot of them do not even have a way out of this conundrum. So Article 22 has come and provided a saving grace for everybody. Has provided a saving grace for everybody to be able to walk out of that marriage with at least something substantial, assuming some assets were acquired in the course of that marriage. Now, we also have Section 20 of the Matrimonial Causes Act. And before I started my talk, I was discussing with my friend and my lord here that Section 20 for me creates a situation where before the marriage, let's say the man is a man of means or the woman is a woman of means, and they marry. And in the context of the marriage, they don't acquire any properties and there's divorce. Maybe you can rely on Section 20 for some share of the property, not necessarily showing that you jointly worked together to acquire it. So that is how I see the Section 20. So even if properties were not acquired in the context of marriage, and it's not uncommon to find that some people come into marriages. In the US, you notice we have prenuptial agreements among other places. In Ghana, as to whether prenuptial agreements are even legal, is another discussion for another day. So you will notice that Section 20 of MCA also makes this provision so that you and I, who find ourselves in situations where we are unable to put properties together in the context of marriage, are able to walk away with something small to cater for the losses we may have incurred by reason of the marriage. That is if, and don't forget, I was telling Dennis a while ago that one guy came complaining that why are all the speakers speaking in favor of women? And I said, oh, they are not speaking in favor of women, but if you understand the historical context, you know why our laws are the way they are. And Mamea has done a very good job telling us there were points where women did not even have the right to inherit from what they have contributed to building. And we've gotten to a point where we are recognizing their contributions towards those properties. That is why it appears that all the speakers are speaking in favor of women, but the law is blind. It's looking at what each person has done towards the acquisition of the assets. So that is it for section. So the legal framework that governs spousal rights in the context of divorce is Article 22 and Section 20 of MCA, which gives you the right to some property. Also, somehow around 2020, in the light of all the decisions that came out, we passed the New Lands Act. I don't know if any of you has gone to the bank in recent time to take loans and attempted to use your matrimonial home as collateral. Sometimes the banks will ask for consent of your spouse. Now, under section 4738 of the Lands Act, if a property is acquired in the context of marriage, you cannot even use it to even secure loan or sell, as Mame already said, without the consent of the other spouse. Now, there's an interesting provision also there, and that cures the situation where properties that are acquired in the name of one spouse only, where mostly the woman will be complaining that all the properties are in the name of the man. If you look at section 37 of that same law, it says that if a interest in land is acquired in the course of marriage, in the name of one spouse, it shall be presumed to be for both spouses. So, as it stands now, if today I'm married and I go to buy land at airports, and I say, "Oh, Papa, just put it in my name." If my wife is able to show that that property was acquired within the marriage, it wouldn't matter whether it is in my name or not. The presumption will be that it is for both of us. But in all of this, the law does not create any automatic right for you to get equal share of any property acquired in the course of the marriage. And that is why the equitable distribution comes in. Now, when we say equitable distribution, we are just looking at what is fair on the facts of each case. So let's take, for instance, I already said that there are certain rules that are expected of a husband and a wife. As to whether those are legitimate expectations or not, that is a discussion for another session. Now, assuming I'm a sit-home husband, and my wife goes out to work and bring in revenue, and all I do is to just be home. And we've built so many properties, and I want out. After some 10, 15 years, I want to walk away. Now, I file for divorce and ask the court to split the properties equally because they were acquired in the course of marriage. The law presumes that properties jointly acquired in the course of marriage should be shared equally because that is what is fair or equitable. Now, we have to look at the facts of that particular case. Did I really contribute, not financially per se, to the acquisition of those properties? Now, we'll have to look at what I did. Okay, what were my expectations? Did I perform all of them? And how did that impact or affect or contribute to the acquisition of those assets? Now, we reverse it, because mostly it's the women who find themselves at home. If you're a woman and you're at home, and in the course of divorce, you make the same claim, we'll look at what were the expectations of you. Did you perform those expectations as reasonably would be expected of any person in your position? Now, so let's take, for instance, there are children. Of course, you carry the children. You carry them for 9 months. You gave birth. You breastfed them. Now, we are looking at a situation where maybe there are about 4 or 5 nannies. There are about 4 or 5 cooks. There are about 4 or 5 security men. Let's say you have access to an excess number of helps in your house who are helping you with all these activities on a daily. And your husband is the one who pays for these people. He pays for the gardener. He pays for the nanny. He pays for the cleaner. He pays for the security man. He pays for the drivers. He pays everything. Will it be fair? And this is a question I leave with you. Will it be fair in that context for the property to be shared 50-50 or equally? That's a question I'll leave with you to agitate over. Now, let's also look at, I've talked briefly about divorce. My sister already talked about it. But let's look at where there is death. Same couple, one passes on to eternity. Same properties. But then the law says that, you know what? Since the man is no more or the woman is no more, we are going to distribute these properties where there is no will by a different regime, which is PNDC Law 111. Has anyone heard of PNDC Law 111 here? Aside the lawyers and then my lord and the judges. PNDC Law 111. And when we decide to apply this law, the same properties, same party, but in this case, it says that you are entitled, assuming you had, in the course of the marriage, you and your wife, or you and your husband were able to acquire 10 houses together. The law says you're only entitled to one by right. You and the children have one. And that one, you cannot even own it exclusively. You own it with your children. However, if you had opted to divorce, the law says that you get, if you're able to prove that you contributed, you get 5. But if you wait, and abide by your Christian or religious doctrines and let death do you part, the law says you are getting this percentage of the assets. Now, the question is, and I leave you since my time is up. We will continue this. I'm sure Dennis will have another session. Why should the same property, same party, and yet the person's right to a share of the property diminish in the event of death and in the event of divorce? Why should we have two different rights? Or why should my right to A be more and my right to B be less? So I am of the view that if the law is operating on the presumption that properties acquired in the course of marriage are presumed to be jointly owned, then that presumption shouldn't operate till the point of death, such that the surviving spouse can claim a certain percentage of the assets, and then the remaining assets, which we can now ascribe to the deceased, will be shared as his personal property, because PNDC Law 1 focuses on personal property. So my Lord is here, and I'm hoping that very soon a matter like that will come before them, for them to set the law clear on this matter for us. So I end my discussion on it. Thank you very much.